Can we agree to disagree on the legalese?
We are not going to agree to anything. This is not your game to play here.
So you're saying that I have to say the words "I understand"?
Sir, I'm not saying that you have to say anything. You can play games with me all day. I got all day. I got all day. Have a seat. Do not interrupt me.
I can object to
Do
that.
not interrupt. Do not. One more time. You're going. Open this matter, sir.
Yes, sir.
I do have to advise you that in this case, you are charged with the offense of assaulting, resisting, or obstructing a police officer. That is a high court misdemeanor felony, punishable by up to 2 years and or $2,000 fine plus court costs. You understand that?
I understand your charge.
You understand also that there is great peril in one representing themselves. You understand that, sir?
I'm not afraid, Your Honor.
Did you understand what I just said? That there is great peril in representing oneself.
I comprehend what you're saying, Your Honor.
Hey, what? Either you're going to answer my questions and you're going to answer them properly, or we're going to have a long time and I'm not going to have these people wait. So while you decide how you're going to handle this, I'm going to have you have a seat. I'm going to pass your case. You will come back up and you will learn how to operate within this court. Plain and simple. Have a seat. Have a seat. And you might want to wipe that smirk off your face while you're doing it. State your name.
Good afternoon, Your Honor. My name is Daniel Magoo.
I have stated the admonishments that I was giving to the defendant representing himself. I apprised him of the maximum penalties and the charges. Apprised him, and sir, I'll ask you the question again. You understand that there can be great peril in representing yourself.
I fully recognize and acknowledge the seriousness of the charges, which include allegations of
Not my question. You understand that there can be serious peril.
The judge repeatedly orders the defendant to sit down, warning him not to interrupt, and making it clear that the courtroom is not a place for games or wordplay. When asked whether he understands what the court has said, the defendant responds with evasive language, attempting to debate semantics instead of answering directly. The judge grows visibly frustrated, reminding him that this court operates by the judge's rules, not the defendant's. As the defendant continues to resist giving a straight answer, the judge firmly states that the case will not proceed until the defendant learns how to conduct himself properly in court. The tension escalates as the judge passes a case temporarily, warning the defendant that continued disruption will not be tolerated and that respect for courtroom procedure is non-negotiable.
Representing yourself.
I recognize what you're saying, and I'm fully prepared to proceed with this matter.
Will you just do me a favor and answer my question? Do you understand that there is great peril in representing oneself?
I recognize that.
Okay, then stop there.
Yeah.
You recognize that.
Recognize.
Do you understand that that in any of the proceedings that the court would hold you to the same standards as if you were a practicing attorney, will give no leeway one way or the other, will show no favoritism or no bias because you are representing yourself. You understand that, sir?
I recognize what you're saying, Your Honor.
You know what? I don't know why you just won't understand. I'm asking you, and I need a direct answer, whether you understand what I am saying, not whether or not you're recognizing the words. Do you understand what I am saying?
I overstand what you're saying.
You want to be,
Your Honor.
You have a seat.
I'm not.
Have a seat.
Your Honor, I haven't had.
Have a seat. You can play games with me all day. I got all day. I got all day. Have a seat. The other one's in custody. I realize we are now at least caught up within an hour. I think those that want to go probably want me to take a break about now. So I'm going to take about a 5 to 10 minute break. I'll come back out and then I'll call the case. The court's going to stand in recess.
Good afternoon, Your Honor. Daniel Magoo. Here in Juris.
All right. So on this matter, I was apprising you of your rights. I told you about the charges in this case. We get to the point of understanding that there is a certain.
When the case resumes, the judge carefully explains the charges against the defendant, stating that he is accused of assaulting, resisting, or obstructing a police officer, offenses punishable by jail time and fines. The judge emphasizes the serious risk involved in representing oneself, repeatedly asking whether the defendant understands that self-representation carries great peril. Instead of answering clearly, the defendant responds with phrases like, "I recognize what you're saying," and "I overstand," prompting the judge to stop the exchange and demand a direct answer. The judge warns that the court will hold the defendant to the same standards as a licensed attorney, with no special treatment or assistance. The defendant's refusal to say he understands causes the judge's patience to wear thin, setting the stage for a deeper conflict.
Peril in representing.
Listening, sorry. My notes, I apologize, Your Honor. I meant no disrespect.
The court will treat you the same as an attorney in the case. You understand, sir? Listen closely to my question. Do you understand that?
I do not understand.
You do not understand it.
No.
The court, you will be presumed to know the rules of procedure as well as the Michigan rules of evidence, that the court will not be giving you assistance in regard to this case.
What I'm trying to say, Your Honor, is I do not understand the charges that are pitting against me because they violate a lot of my rights. And the prosecutor served me the discovery packet on the 27th of last month. Since then, I have not received any kind of evidence or any kind of claims that I violated any kind of anything that day. So I'm here waiting for that to occur. So no, I don't understand.
Waiting for what to occur?
Well, under the rights to due process, Your Honor, 4th, 5th, 8th Amendment, there has to be substantiated amount of evidence to accuse me of a crime, like assault on a police officer, obstruction of justice, and resisting arrest. I take these charges very serious, Your Honor. Because of these charges, I have lost custody of my son, and I want to make sure that these justice is served and equity is ensured here.
Sir, I just asked you before whether or not you understood the charges.
And I answered you, Your Honor. I said I do not understand them.
Whether or not
The defendant claims he does not understand the charges, arguing that his constitutional rights have been violated and that he has not seen sufficient evidence to justify the accusations. He explains that the case has cost him custody of his son and insists that justice and equity must be served. The judge interrupts to clarify that understanding the charges does not mean agreeing with them, believing them, or accepting guilt, but simply knowing what he is accused of. Despite repeated explanations, the defendant continues to conflate legal disagreement with comprehension, prompting the judge to bluntly state that the issue is not philosophy or constitutional theory, but basic courtroom procedure. The courtroom atmosphere grows increasingly tense as the judge realizes the defendant is deliberately refusing to engage in good faith.
you disagree with them or not, it's not the issue. The issue is do you understand what you are charged with?
I do not understand, Your Honor.
Is there a reason other than what you said that you do not understand?
I can elaborate a little further, Your Honor. I'm still
I
waiting.
wish you wouldn't. I just need to understand why you don't understand.
I'm
the
trying to get there, Your
charges.
Honor, if we could talk
I'm
about it.
not asking you whether or not you agree that you should be charged. I'm not asking whether or not you
You're asking-
believe that you did it. I'm not asking any of that. I'm asking whether or not you understand what you are charged with.
Can we agree to disagree on the legalese?
We are not going to agree to anything. This is not your game to play here. You play by my rules.
So you're saying that I have to say the words, I understand?
Sir, I'm not saying that you have to say anything.
Okay.
You know what? Here's the thing. I am not going to play this game with you.
I'm not.
So what? No, you are playing a
I'm
game.
not.
So no, you are. And do not interrupt me ever again. Do not. So what I'm going to do is I'm going to give you a week to think about it, because I'm not going to sit here, call your case up 4 or 5 times for you to sit here and to go through this whole, try to play some semantical game. So I will adjourn this out to December 12th, 2024. I will adjourn it to 9 a.m.
Your Honor.
or I will, do not interrupt me.
I can object to
Do
that date.
not interrupt, do not. One more time, you're going. I'm adjourning the proceeding out. If you are objecting to that, objections noted. It's still adjourned out to the 12th. Bond will continue. You
Your
may
Honor.
leave now.
I have constitutional.
You may leave
violations.
now.
Let's go. Let's go.
I have a right to
You
a
may
counsel.
leave.
Do I not have a right to a counsel?
You want an attorney, you may get want an attorney, sir?
I need somebody to explain the problem here.
Do you wish to be represented by an attorney on this?
I do not need to represent myself. I'm presenting myself. I'm the only one that was there in this courtroom. No one was there. I don't recall anybody that was there that day. I'm the only one that knows what happened, Your Honor.
Do you wish
I was
to be
violated.
represented by an attorney? I'm not going to sit here and argue with you. If you wish to be represented by an attorney,
Your Honor, I have constitutional violations
do
that
you
need.
wish to be represented by an attorney,
You
sir?
take an oath to defend the Constitution of the United States of
Then
America.
if you do not want to answer my question, Mr. Allen, he is to be removed from my courtroom.
After multiple warnings, the judge accuses the defendant of playing a semantic game and announces that the court will not continue the hearing under these conditions. The defendant attempts to object and invoke constitutional arguments, but the judge shuts him down, ordering him not to interrupt again. The judge adjourns the case to a later date, giving the defendant time to decide whether he will follow courtroom rules or obtain legal counsel. As the defendant continues arguing about his rights and representation, the judge makes it clear the decision has been made, orders him to leave the courtroom, and warns that refusal to comply will result in removal. The hearing ends with the judge asserting full authority over the courtroom and making it clear that defiance and word games will not override the rule of law.